I salute you all and I welcome you all. Thanks for always watching these videos. Today we are under the law of evidence, and basically we are looking at a dying declaration. You get a dying declaration. It is also an exemption to hearsay evidence. Bear that in mind. A dying declaration, it is an exemption to hearsay evidence. And basically it is provided under Section 30 of the Evidence Act, which provides that a statement is made by a person as a cause, as a cause of his or her death, or as any of the circumstances of the transaction which resulted into his or her death. In cases in which the cause of the death and the person came into question and the statements, they are all admissible. So bear in mind, the dying declaration is made by a person lamenting that this is the cause of my death. That is the dying declaration. Someone gives an evidence before him or her dying, says that this and this one is the one that caused my death. This is what happened. So bear that in mind for a dying declaration provided under Section 30 of the Evidence Act. So basically, dying declaration can mean a statement uttered by a since deceased person for the purpose of which is established the cause of the death of that particular person. Basically it is made, or it is an exemption to hearsay, as said, because the maker is dead. It is the hearsay because the maker is dead. Which means there's someone that is reporting on behalf of the maker. And in the case of Sabit Vincent versus Uganda, this case provides when a dying declaration must be admissible. For a dying declaration must be admissible, but a caution must be taken. Understand? A caution must be taken when relying on such evidence to convict someone, because such evidence lacks cross-examination, and there's no how court can determine its truthfulness. You understand? Because the fact is, someone can report that it is a dying declaration when they had grievances with the accused person. So that's why they say that the courts must take caution on convicting someone on a dying declaration. And we have the elements of a dying declaration. What makes a dying declaration to become valid? First of all, it must be made, or it must be death. There must be death of the maker. Basically, there must be death for a dying declaration to occur, to be entered. Take for instance, if you say that so and so has killed me, but later you don't die, that evidence cannot be taken as a dying declaration. There must be death of the maker. The maker must die. So bear that in mind. When you read the case of Chandra Sekera versus the king, the death of the deceased after the accused had slit the deceased's throat. The evidence that was given by the deceased was admissible on those grounds because the maker had died. Also, you have another element. The dying declaration must be complete. What do I mean complete? Is that it must really give facts showing that this is the person that did the particular act. It must be complete. For example, there is a case of Wag versus R. Here the deceased was shot by the accused. Then in his statement he says that I have been shot by, he ended there. So court held that this was a shot and it could not be couldn't be admitted because the dying declaration was incomplete. You understand? A dying declaration must not give a room for doubt or a room for other opinions. If you say that you have been shot by who? This person cannot just say that by the other one, which means that's not a dying declaration. They have to look for some other evidence to back up the conviction. Then the statement or the dying declaration must be corroborated. What do I mean by corroborated? There must be some other evidence to back up a dying declaration. Because the dying declaration, the reason as to we say that court must take caution on considering it, because they presume someone may come with false allegations on someone, just being malice. You understand? You have no problem, because just because the other one died, you are saying that the deceased died and say that this is the one that died. The evidence must be corroborated. Some other evidence must be necessary. You understand? For example, the other one threatened. You must corroborate it for a dying declaration to be considered. You get? When you read the case of Pius, son of Akum versus R, they say that the dying declaration must be supported by some other evidence, whereby they said it was unsafe based on the conviction solely on an uncorroborated dying declaration. You get? And also the issue of time. The time frame is also necessary. What do they say, the issue of time? They say that I can't say that so and so wants to kill me. Then it passes a period of like 2 months, 1 year. Then the other one dies. They cannot base on such a dying declaration. The period of time, there must be the proximity. By the time you did your declaration and the time of your death, they look at the proximity. You get? The issue of time. You get? For example, when you read the case of Ara versus Kabatelaini, in this case, realize that 2 days before the deceased dying was burnt down, she had made a statement to her headman that the accused had threatened to burn her in her own house, because he had caused the death of his father by witchcraft. Then the issue was whether this was a valid dying declaration. However, it was considered, because court held that it was admissible under section 30 of the act, which was directly showing or related to the occasion of the deceased death, and was in the circumstances resulted into the death. 2 days were not all that long. 2 days were not the issue of time. It was nearer. You get? So bear that in mind, the issue of time. But if the time frame is large, for example, you make someone wants to burn me, it passes 1 year, 2 months, then that cannot be considered as a dying declaration. Time, the proximity. By the time you make the declaration and the time of the death, they must be nearer. So bear that in mind. That is briefly a dying declaration. And the dying declaration is an exemption to the general rule of hearsay evidence, that hearsay evidence is not admissible, is inadmissible. Yes, thank you for watching.